Peace Conference, and the second the Hague Peace Conference. And they established the Permanent Court of Arbitration, PCA. And this PCA is still 1899 until now, functioning up to now. And in 1958, the United Nations General Assembly adopted model rules on arbitral procedure. So this is mainly in connection with interstate arbitration, because the United Nations General Assembly, why it concerned with not international commercial but interstate arbitration. And model rules. Model rules mean the states, they can follow. It's not legally binding, but states can follow when they make arbitration. I mean laws and procedural laws in their country. They can follow this model law. Okay? So in this model law of 1958, this international arbitration was defined as a procedure for the settlement of disputes between states. This is the first requirement of interstate arbitration. Settlement of dispute between states, that's an interstate. Number two, by a binding award, the arbitral award is legally binding. For the bills of law, the arbitrators apply what? Apply law. And as a result of an undertaking voluntarily accepted, and the basis of arbitration is consent of both parties. So these are the elements of an interstate arbitration, and this is the official definition of interstate arbitration as laid down by the International Law Commission. So that is why, like in the domestic arbitration and also international commercial arbitration, in the case of interstate arbitration also, consent is, all types of arbitration, consent is a prerequisite. Consent is the basis of arbitration. Consent to arbitrate. Yeah? Consent to arbitrate. So this consent to arbitrate can be expressed in three ways. Number one is by means of an arbitration treaty. An arbitration treaty. Two or more states can conclude a general treaty of arbitration. In the treaty, it provides that all or any particular type of disputes arising between them shall be settled by arbitration. So the best example is the 1899 Convention on the Pacific Settlement of International Dispute. That is arbitration treaty. This convention itself is an arbitration treaty, and which established the Permanent Court of Arbitration, PCA. This is the best example of arbitration treaty. Consent given by means of an arbitration treaty. Number two is an arbitration clause in a treaty, in any type of treaty, general treaty. In any type of treaty, treaty of commerce, or whatever type of treaty, there will be a clause in the treaty. That clause is known as arbitration clause. Okay? Arbitration clause. And in this, the clause provides that any difference respecting the matters regulated by the treaty shall be determined by arbitration. So that's one clause. We call arbitration clause in a general type of treaty. Whatever type of treaty, it doesn't matter. The only thing is that there must be a clause in the treaty which provides that if there is any dispute over the treaty, then the parties shall submit to arbitration. That is the second way. The third way is by means of a special agreement or a compromise. In French term, we call compromise. This is in international court, and tribunal also use the term compromise, special agreement. This is consent ad hoc. We call consent ad hoc. Ad hoc means temporary consent. For a particular case, a case or a dispute rules between two parties, the two parties enter into a special agreement known as compromise, and then they submit to arbitration for that particular case only, for that particular dispute only. So that is called special agreement or compromise. This is one way of giving consent to arbitrate. I give here two examples on the basis of this special agreement or compromise. The first arbitration is Saint Pierre and Miquelon arbitration, Canada versus France. The second example is Guinea versus Guinea-Bissau maritime delimitation case in 1985. So these two arbitration cases are based on a special agreement or a compromise. So that is why now I summarize the three ways to express consent to arbitrate. What are the three ways? Number one, by means of an arbitration treaty. The treaty itself is all about arbitration, like the Hague Convention, 1899 Hague Convention on the Pacific Settlement of International. The whole treaty is about arbitration, although the treaty may adopt some other means, but mainly arbitration. Second way is an arbitration clause in a treaty. In any type of treaty, any kind of treaty, there can be a clause which provides that in case of dispute between the parties to this treaty, they shall submit to arbitration. Right? That is called an arbitration clause. And number three is, this is ad hoc consent. Ad hoc consent can be given by means of a compromise or a special agreement. We do not pronounce as compromise, because it's a French, not English term. So compromise, S sound is silent here. Compromise only, not compromise. Okay, now we will go in more detail about the compromise. The compromise is a special agreement reflecting party autonomy. So what is party autonomy? What do you understand by party autonomy?
Parties are free to use the law and stuff like that, and the police.
So autonomy means freedom. No? Parties are free. Freedom of the parties. They can freely choose the arbitrators. They can freely decide about what should be the law to be applied, right? All are based on the parties. Based on parties' agreement or parties' consent. Parties are free to agree on anything they like. That is called party autonomous. Parties are autonomous. They have autonomy. They can do whatever they like. That is the meaning of party autonomy. And this is the basics of the contract law also. In law of contract, freedom of contract, right? Parties are free to include any terms they like in the contract. That is called freedom of contract. So also in the arbitration also, there is party autonomy. The parties are free to choose anybody they like as arbitrators. Okay? So in the compromise, reflects party autonomy. That's why the compromise shall specify the following matters in detail. Now, 6 matters I give here. Number one, the undertaking to arbitrate. The undertaking means the agreement, the consent. We agree that our dispute shall be decided by an arbitration. Okay, that's an undertaking, agreement, or consent to arbitrate. Number 2, subject matter of the dispute. What is the subject matter? Meaning that what are the legal issues involving arises from this dispute. Number 3, the method of constituting the tribunal and the number of arbitrators. How to constitute the tribunal and how many arbitrators should be there? 1 arbitrator or 3 arbitrators or 5 arbitrators or mixed arbitral tribunal. Anything they like, they can put in the compromise. Number 4, the law to be applied by nation. They can choose the law to be applied. It should be international law, or it should be equity, or it should be even Sharia for Islamic. In some African countries, they use arbitration, then they choose Islamic law, Sharia, as the law to be applied. Sharia. So this is up to the parties. And the procedure to be followed. The procedure of the arbitral tribunal, what procedure to be followed? How to get the evidence, how to make the witnesses, everything must be agreed by the parties in the compromise. And the time limit within which the award shall be rendered. This is the The mandate given to the arbitral tribunal. The tribunal must finish or complete this arbitration within 1 year or within 2 years, something like that. The time limit must be given, can be given in the compromise. That's all these points are to be agreed by the parties, and parties are free to agree on these points. That is called party autonomy. Any question up to now?
Okay. No
Okay.
problem.
Who is to arbitrate? Who should be the arbitrators? So this is also, as I told you before, to be chosen by the parties themselves. Parties are free and they are autonomous to choose anybody they like. That's why the states that conclude the arbitration treaty or that adopt the compromise, they agree upon the arbitrators. They have to agree upon how to constitute the arbitration tribunal and how many arbitrators should be there. For example, there can be a single arbitrator. We call sole arbitrator. Sole are one arbitrator only, single or sole arbitrator. And that he may be the head of a state, head of a third state, or is a very respectable person, a dignitary. I'll give a few examples, 3 examples here, 3 arbitration cases, very famous arbitration cases. Number one is Clipperton Island case, that is the territorial dispute. Who, who, who can exercise sovereignty over Clipperton Island? France versus Mexico. In this case, the two parties chose King Victor Emmanuel III, King Victor Emmanuel III of Italy, the king of a country. They choose the head of state or the king of a country as arbitrator. So he's a very influential person and he also knows the law, the law governing territorial disputes. Second example is Palmas Island case. It's also a very famous leading case on territorial disputes. And the two parties agree. In this case, USA and the Netherlands. They agree to choose Judge Max Huber, very famous judge, as sole arbitrator in this case. And in the Rainbow Warrior case, Rainbow Warrior arbitration, the UN Secretary General was offered to arbitrate this. United Nations Secretary General was offered. So these are the examples of what type of persons are chosen as arbitrator, especially as a single or sole arbitrator. The second type of arbitration is arbitration commission or arbitral tribunal. Not only one person, only that as it's a tribunal means it is at least 3 persons, 3 or 5 arbitrators. Normally, the number of arbitrators should be the odd number, so that they make the decision easily, majority decision. If 4, for example, you do not use odd number 4 or 6, then difficult to make a decision, right? That's why normally the number of arbitration tribunal or arbitration commission should be 3 or 5 normally. This is second type. The third type of arbitration is a mixed commission. Mixed commission composed of 2 national commissioners. The 2 states, they appoint their own national commissioners, 2 national commissioners. And the third one is the neutral one. He is known as an umpire. Umpire is the neutral one. So altogether 3. Because this is arbitrator from both countries. Both countries are involved, and also one neutral third party is involved. So that is called mixed arbitral commission. First example is Iran-US mixed arbitral commission after the Tehran hostage case, right? Tehran hostage case, and then the Algiers, they mediated. Last lecture I discussed about that one, right? Algeria mediated and they settled the problem. And finally, to decide the cases pending before the US and Iranian citizens and governments, they established Iran-US mixed arbitral commission. And from both sides, Iranian arbitrator, US arbitrators, and one third party umpire. Okay, the next point. The law applying by the arbitrators. The treaty arbitration or the special agreement, the compromise may stipulate what laws, what principles of law the arbitrators have to apply. Normally, they include general rules of international law to be applied. Normally, in normal cases, we say that the arbitral tribunal shall apply the general rules of international law. It means the sources of international law as provided in Article 30 Clause 1 of the Statute of the ICJ. According to Article 30 Clause 1, what are the sources of international law? Treaties, customary international law, general principles of law, judicial decisions, and teachings of most highly qualified publicists. They are the sources of international as laid down in Article 38 of the Statute of the ICJ. And normally, arbitral tribunal also follow these sources of international law as general rules of international law. But if the parties agree, they may also apply equity, rules of equity, principles of equity. We do not apply the law. Arbitral tribunal must not apply the law, but they apply principles of equity. This is also possible. Or other rules, like as I told you before, even Sharia, Islamic law. If the two parties are Muslim countries and they like Sharia to be applied, then they can include that now. Arbitral tribunal should apply Sharia as the governing law, something like that. So they are free to include any law they like for the arbitrators to be applied. And also, they can freely lay down the rules of procedure, procedural law. So that's not only the substantive law, but also the procedural law to be followed by the arbitrators. That is the law part. Binding force of arbitral award. An arbitral award is final and conclusive, meaning that there is no appeal. Not like courts, right? In court system, there can be appeal, right? Especially in domestic courts, appeal. But in arbitral tribunal, there is no appeal. Arbitral award is final and conclusive, and it is legally binding upon the parties. If one of the parties to the arbitration do not comply with the award, arbitral award, then what the winning party can do? To apply the enforcement of international law, to enforce international law, to enforce the arbitral award by coercive means. Okay, what are the coercive means or compulsive means to apply, to enforce the award? What do you think? You have basic, knowledge of international law, right? Some of you already done foundations of international law, correct? If, for example,
Okay.
How to enforce the law? The what?
For example, imposing sanctions and stuff like that.
Sanction is a bit controversial. Sanction can be done normally by the Security Council, but as an individual state, you can do coercive means like, for example, retortions, reprisals, countermeasures. These are the coercive means of enforcing international law. But sanction, of course, is also possible, but sanction is a collective action. But it is effective only under the UN Security Council. Security Council make a resolution to impose sanction on the state which is not complying with arbitration. That is the enforcement by the Security Council. But the parties itself can use the coercive means like retortion, reprisals, countermeasures. Okay? Now, I will make a very brief comparison between arbitration and court. The difference between arbitration and court. Court, you know very well, right? Court system, especially in the national legal system, as well as also international legal system. Court is something like the judges are there already, right? The local court, federal court in Malaysia, from the federal court, the Court of Appeal, High Court, the judges are already there. Can you choose a judge? Can you choose a judge you like it? You like him? No, you cannot choose. You have no right to choose a particular judge to decide your case, right? Have no right. So also in ICJ, the judges are there already fixed. And in a full court, then all the 15 judges will be there, apart from those who will be sick or absent. The full court will be there. You cannot choose a judge. But in arbitration, as I told you before, because of the principle of party autonomy, the arbitrators are to be chosen by the parties themselves. Because arbitration is based on party autonomy, arbitration is leaving the settlement dispute as much in the hands of the parties as is possible. As far as possible, to put the settlement dispute in the hands of the parties. The parties can free to choose any arbitrators they like. Parties are free to decide on what law to be applied, what procedure to be applied, what method of settlement, something like that. And then what time, what place, the place of arbitration, within what time the arbitration has to be completed. Everything has in the hands of the two parties. That's why arbitration is very free, but courts are not free. Okay? And then some arbitration are normally can be conducted confidentially without any publicity. But court must always be in public, cannot do confidentially. So these are some of the differences between a court and arbitration. And another important difference is because we call the concept of speciality. In court, the judges may not be an expert in a particular specific area of the dispute. For example, Malaysian Federal Court, for example, an international law of the sea case, a case involving law of the sea dispute brought to the court. There may not be law of the sea experts among the judges. They know generally about law, criminal law, civil law, they do, but specifically this law of the sea, many judges may not know that. So also it is a dispute relating to World Trade Organization brought to the court. The court may not know, court may not have expertise in World Trade Organization matters, something like that. But arbitration is not like that. Based on these, the subject matter of the dispute, the parties can choose. For example, it is a maritime dispute, then the parties may choose the arbitrators who are maritime law experts. If it's a trade dispute, the parties may choose arbitrators who are trade law experts, sale of goods law experts, territorial dispute experts, something like that. So that there is specialty in arbitration, but in court there is generality only. The judges may know or may not know about the specialty of the subject matter. That is also another difference between arbitration and court. Any question?
Bro, in arbitration, the consent of parties are required, right? What about the court? Is it required the consent of both parties?
No, the court is there, right? The court is already established. How can you apply the consent? Consent is not necessary at all. Okay? Because federal court, right? Do you have any consent? Appointment, the judge already appointed, right? They are there, right? It's compulsory for you to go. And the head of for example, the Chief Justice of the Union in the federal court, for me, Chief Justice of Malaysia, will decide, or registrar will decide your particular case, then who will be the judge? Based on the rostrum, we will choose any particular judge. Find the court itself. The court will decide. Not you. You cannot choose. Right? But arbitration, you can choose who should be the arbitrators.
So is there in the court, is there any enforcement mechanism about the court?
The one that is very clear, right? Very simple, very clear. Courts, you do not follow the court decision, that the police will arrest you, they're put in jail. Very simple. Right? in domestic law, in national legal system. But international law will be a bit different. In international law, international ICJ, for example, ICJ judgment, who will enforce the judgment? Security Council. You have to submit to the Security Council, and Security Council can impose sanctions or can even use military force against the state which is not complying with the judgment of the court. Okay? Utility of arbitration. Arbitration is, as I told you before, since antiquity, long time ago, states used arbitration as a means of settling disputes. One of the most effective method of settling disputes. And as you all know, arbitrators are judges of their own choice. And also, not like inquiry and conciliation we discussed in my last lecture, right? Last week, inquiry, conciliation. So their decisions or their recommendations are not legally binding, right? Because they are diplomatic means only. Not arbitration is adjudicative means, like court. Arbitration court are adjudicative means because the third party will decide according to law. So that is why the decision is legally binding. And if you do not follow the decision, there will be enforcement. Enforcement means methods of enforcement which is allowed in international law. You can use methods of enforcement. But inquiry, conciliation, there is no enforcement. These are also not binding. Because of these advantages, arbitration is accepted as an appropriate way of handling, especially certain types of dispute. And in maritime law dispute, territorial dispute, arbitration used. Even in the past, they do not even go to ICJ. They go to arbitration for the territorial disputes. I will give a few examples here. Very famous territorial disputes go to arbitration. First, Lake Ranox arbitration, France versus Spain. Second, Run of Kutch arbitration, India and Pakistan. Decision on west boundary between India and Pakistan. The Channel arbitration, delimitation of the continental shelf between UK and France. All these are territorial or quasi-territorial disputes, and they go to arbitration. Another example, St. Thierry and Miquelon arbitration concerning delimitation of maritime areas between Canada and France also went to arbitration. And when we look at the international treaties, international convention also, we will find an important role of arbitration in bilateral as well as multilateral conventions. The best example is 1982 United Nations Convention on the Law of the Sea. In the dispute settlement system of the Law of the Sea Convention, mainly Article 287, arbitration is given much preference. So many provisions of arbitration. And the two annexes to this convention, Annex number 7 and Annex number 8. These two annexes are entirely on arbitration. As Annex number 7 is ordinary arbitration procedure. Annex number 8 is special arbitration. Okay, so there are two types of arbitration, and there are two annexes in the convention regarding to settle disputes by means of arbitration. That's why Law of the Sea disputes are also settled by means of arbitration, and there are two special annexes in the UNCLOS, Annex number 7 and number 8 for arbitration. Okay, now we are discussing on now very famous now because of the South China Sea dispute, right? Permanent Court of Arbitration, PCA. When we study arbitration, then we cannot escape from studying this PCA, the Permanent Court of Arbitration, which is very important intergovernmental organization which encourage the use of arbitration. And as you all know, this PCA was established by 1899 Hague Convention for the Pacific Settlement of International Disputes. The 1899 Hague Convention was adopted in the first Hague Conference. And the second Hague Conference was in 1907. The two Hague peace conferences, first 1899, second 1907. They are very important in the international dispute settlement, and they mainly emphasize on arbitration. Although they talk about other means of peaceful settlement, but they mainly emphasize or focus more on arbitration. And Article 16 of the 1899 Hague Convention stated that arbitration is the most effective and at the same time the most equitable means of settling disputes which diplomacy has failed to settle. Now, diplomacy, I told you in my last class, last week, diplomatic means of settling dispute, right? Diplomatic means, what are the diplomatic means? Number one, negotiation, inquiry, mediation, conciliation. These four methods are we call diplomatic means. They cannot make binding decisions, but they are by means of diplomacy. First, the two parties themselves settle by means of negotiation. If negotiation fails, the third party involvement. Mediation is third party involvement, inquiry, third party involvement, conciliation, third party involvement. But they cannot make a binding decision. That's why we call all these four methods as diplomatic means of settling disputes, and they are based on diplomacy. But these diplomatic means are not successful, fail to settle a dispute, then the most and effective way of settling dispute is arbitration. That is stated in Article 16 of the 1899 Hague Convention. Article 20 of the Convention formally established the Permanent Court of Arbitration. Why we use the term permanent court? Since 1899 until now, it is something like permanent. That's why it is something like the dream for a permanent international court, right? So many states, so for so many years, they tried to establish International Criminal Court as a permanent international court. So also now the Hague Convention established the PCA as a permanent court of arbitration. That is why it is accessible at all times. To facilitate recourse to arbitration for international disputes, which cannot be settled by means of diplomacy or by diplomatic ways. And the PCA was the first permanent intergovernmental organization. It's IGO. Why IGO? It is not NGO. No? PCA is not an NGO, non-governmental. PCA is an IGO because members are sovereign states. The members of the PCA or contracting parties to the PCA are this Hague Convention are states, sovereign states. So that's why PCA is an intergovernmental organization, IGO. And this organization provides a forum for resolution of international dispute through arbitration and other peaceful means. How many states are parties? 125. It's quite impressive, right? The convention is adopted and signed and ratified by 125 states, parties. And where is the headquarters of the PCA? Together with the ICJ. So the two courts, PCA and ICJ, are located in the same place, Peace Palace in The Hague. Peace Palace. Both courts. Now, ICJ, International Court of Justice, and PCA, Permanent Court of Arbitration, are located in the Peace Palace in The Hague, the Netherlands. So, since normally, even though this is an intergovernmental organization, and it is permanent in nature, meaning not ad hoc or not temporary organization, not a conference. It is a permanent organization. That's why there must be a permanent, secretariat. So this permanent secretariat is known as International Bureau. International Bureau is the secretariat of the PCA. And It consists of an experienced team of legal and administrative staff of various nations from various countries, administrative staff and legal staff. And this secretariat of the PCA or International Bureau is headed by the Secretary General of the PCA. There is a Secretary General of PCA who is the head of the Secretariat or International Bureau. And International Bureau provide all matters relating to the PCA, administrative support to the tribunals and commissions, official channel of communication to safely keep all the documents of the PCA since 1888 up to now safe, keeping or custody of all the documents, and then financial administration, logistical and technical support for meetings and hearings, travel arrangements of all the arbitrators who are members of the court. All these things are to be done by the International Bureau or the Secretariat of the PCA. Now, members of the court, although it is not really a court, but this is the term court, right? It's a permanent court of arbitration. Permanent court of arbitration. So that's why they also use the term members of the court. These members of the court are actually they are potential arbitrators, and they are appointed by the states, contracting parties, state parties. The state parties, who are the parties to this convention, they appoint potential arbitrators, and these potential arbitrators, the list of all these potential arbitrators established as they are members of the court. They establish this court, PCA. So how many persons each contracting party can nominate? 4 persons, up to 4 persons. Each and every contracting state to the Rome, convention, they can nominate maximum 4 persons, up to 4, but maximum 4 persons who are known competency in international law, of the highest moral reputation, and then they agree to accept the duties of arbitrators. Okay? So these persons nominated by each and every contracting states, they establish members of the court, and they are elected or they are nominated for 6 years term. So these, if 2 states are in dispute, and if these 2 states want to use this arbitrator, these members of the court, or from the list of arbitrators, they want to use the arbitrators to establish the arbitration, they just contact the MCA, the secretariat of the MCA, and they approve it as secretariat, and then after that, from the list of the arbitrators, they can appoint arbitration tribunal. It's something like that. So these, the members of the court of PCA, they are a panel of potential arbitrators. Their first function is they are potential arbitrators, the first function. The second and very important function is the members of the court from each contracting party constitutes a national group. And in next week, we are discussing about ICJ, how to elect ICJ judges, right? I will discuss about that. ICJ judges will be elected by also national groups. So now, what are the national groups? National groups are mainly these members of the court chosen by each contracting party. For example, in Malaysian government chose four experts as members of the PCA. These Malaysian 4 members, four arbitrators or 4 members of the court, they form a national group, Malaysian National Group. And this national group has the power to nominate candidates for election to the ICJ. They can nominate candidates for the election of judges to the ICJ. they can nominate. So this is their power and function. So the national group, which is in the PCA, chosen by each and every contracting state, they constitute a national group, and this national group can nominate candidates for the election of the ICT. So any question on that point? Okay. You relate these to next week class on judges, election of judges to the ICT. Okay. Now, who are the members of the court, PCA, appointed by Malaysia? Currently appointed by Malaysia. Malaysia appointed 3 members currently in the list. You can visit the website of the PCA. You can visit the website of the PCA, and it is currently in the list. The appointed by Malaysia, 3 members of the court, or 3 potential arbitrators. Number 1, Tan Sri Muhammad Ghazali Muhammad Yusof. He was a former federal court judge, former chief registrar of the Supreme Court, and former Solicitor General of Malaysia. You see the position, right? So these are the big guns from the particular country. Number 2, Datuk Anantam Kasinata, a former judge of the Court of Appeal of Malaysia. Number 3, Miss Sitpa Selva Ratnam. Her qualification, Master of Law, University of Cambridge, Barrister at Law, Lincoln's Inn, and counsel a wide range of corporate insolvency, commercial, maritime law disputes. And she is also member of the International Court of Arbitration of the ICC, International Chamber of Commerce. So all have well experienced, judges and arbitrators. Judges and arbitrators. They are appointed by Malaysia as members of the PCA. Members of the PCA. And you can see in the list of Malaysia, you can see 2 are the Malaysian Indians. The Malaysian Indians are very good in law. Very good in law. You can see this. Out of the 3 members, 2 are the Malaysian Indians. Now, arbitration rules 2000, the latest arbitration rules of the PCA. You can visit the website, and I will give you only important points only here. Article 6, appointing authority. Who have the appointing authority or from the list of the arbitrators? The Secretary General of the Permanent Court of Arbitration, who is also the head of the International Bureau, the head of the Secretariat, Secretary General of the PCA, shall serve as the appointing authority. Number of arbitrators, Article 7 to 10, there can be a sole arbitrator, there can be 3-member panel, and there can be 5-member panel. And model arbitration clause, this is the model arbitration clause is given by PCA, but it is up to the 2 parties. If they want to make a compromise and they write their separate arbitration clause, it is okay. But this is the sample, a model here, a sample arbitration clause is given by the PCA rules 2012. Okay, now we stop for a while here. And 11 o'clock, we start again. Okay. Have a short break. Thank you.
Thank you so much, Prof.
Thank you.